This week we're moving on to a focus on theory and the various ways in which you can use legal theory as a researcher to enhance what you do. And there's always been an interesting tension in law between theory and practice, partially coming from the fact that law emerged out of a practical profession, and it came out of a profession where there were apprenticeships, much like the TAFE system implements today. And law's a relatively latecomer to the academic world, and it's always had a slightly ambivalent attitude towards theory because of that. At its worst, you can see it as a sort of a dismissal of theory by people who say, well, lawyers, we only care about what the law is. We don't care about what these highfalutin theories are all about. But at the end of the day, that does a real disservice to what theory actually does for you, which is provide a toolkit of ideas and options, perspectives from which you can examine and analyse a legal issue, so that you can actually think about things, and rather than just look at a set of laws or a case or whatever and just go, well, I think it's this on the face of it, you can put it into a bigger context and you can actually draw comparisons and you can see it as part of something that's bigger. I think that people's attitudes to theory stem a lot from their experience of studying jurisprudence, and I hope you had a good experience studying jurisprudence, or will do, depending on what stage of your program that you're at. I have my concerns about the traditional law approach of sticking jurisprudence by itself in a subject and saying, well, there you go, you do theory once, you do it in one subject, and it's all corralled with a nice fence around it. I think it's more productive to actually spread theory out throughout a program. But this is the model the Priestley 11 universities tend to use. So, as I said, I hope you had a great experience, or will have a great experience of jurisprudence. But I think it flavours people's attitude to theory later on. And if they have a good attitude, if they have a good experience, they tend to be very positive about theory. But if they found it was dry, obtuse, dull, and pointless, then they will feel that way about theory later on as well. The analogy I like to use when I talk about theory is the difference between a mechanic and an engineer. A mechanic does all the practical stuff, an engineer knows all the theory and understands how to put things together. Which is better? Well, neither. You need both. If your car breaks down, you need a mechanic who can fix it then and there. You don't need an engineer who can tell you about the mechanical principles on which a car is built and explain quite what are the defects in the way this particular model of car was built. You want your particular car to be fixed. However, if that's all you ever do as a society is just fix things that are broken and you never understand why they're broken, then you never go anywhere. You never develop anything new. You never develop any particular new technologies. So I think that's where the practice and theory split often ends up in law, that we need people who can get in and help people solve disputes and use the tools that are available to them. But we also need people who can understand how the system works and understand how to fix the system and make it work better, and also identify where there are serious problems in the system. So we've had issues, for instance, with gender bias in the system, and if without the use of feminist theory to help us understand why it was that a law that on the face of it seems to apply to everyone equally, but substantively has very different results for different people depending on their gender, well, then that theory comes along and helps us understand and contextualise and give us a rationale for change. So this week encourages you to think about the idea of theory in a positive way, and that it's not going to bite, and it's not something that is dull or tiresome. Certainly some of it is. And then that goes for everything, I think 90% of everything is dull and tiresome. But you grab the 10% that is interesting and you run with that. Theory, as I said, provides a set of tools for you. And I've mentioned the concept of critical analysis quite frequently throughout this term. And this is where theory helps. It helps you develop that critical analysis. It develops what we call a theoretical backbone that you can use to explore an issue. You can present the different sides from the perspective of theory, analyse it, and it'll give you something to go with. And people who have been struggling with creating critical analysis, I would suggest it's getting to grips with the different legal theories that underpin what you do that will help you understand how to improve that. None of us are very good at critically examining something just by ourselves. We need the support of others. We need the support of those who've come before us, and theory provides that sort of support. All right, so the readings this week, there's 2 readings, and the first one by Dagan and Kreitner talks about the difficult place for theory in law, and it talks about some of those issues I mentioned previously about the history of law and its problematic relationship with theory, as opposed to a discipline like sociology, for instance, that tends to be organised around the study of race, gender and class. And while people have vastly different attitudes to those issues within sociology, it provides a kind of a nice standard base work from which all sociologists in Sociology 101 can get started and get an understanding of what it is they do. We don't really do that in law, and Dagan and Kreitner are suggesting that if we could divide it into 3 particular areas, that would give us a framework for understanding how the different limbs of legal theory fit together. And they talk about law and policy. The relationship between lawmaking and the underlying policy itself is one. Another is the socio-historical analysis of law. So we understand why law is the way it is, where it comes from, where it fits into society, where its history is, where it's going. And the third is the idea of law as craft, and that's an examination of what is it actually that lawyers do. There's been a little bit of work, quite a bit of work actually done on judicial discretion and looking at, well, what is it that judges do? It's quite difficult to summarise, and even judges themselves have a great deal of difficulty saying what is judgment. So what is the craft of being a good judge? What is the craft of being someone who's good at drafting documents? Is it a mechanical process? And we're back to that theme that comes up again and again, is if it's mechanical, a robot's going to be doing it for you, or we're going to outsource it to someone who's paid minimum wages to do it. However, if there's more to it, if there's actually an important craft element that the person who creates it is an essential part of it, not a mass manufacturing process, it's a craft process, then that becomes more important. And then we understand what it is that lawyers do that a robot or a minimally paid person can't do. So those are 3 things that those writers suggest, and it's, I think, an interesting starting point to help us understand where we need to go in terms of legal theory to build something that is more cohesive, that's not just a sort of a hodgepodge of different ideas. The other article by Burns and Hutchinson talks about empirical facts, and that leads us into next week's discussion where we're going to look more clearly at data. But it's also couched within the idea of what is the theoretical approach that lawyers take to data, that lawyers take to facts and empirical evidence. And that's always also been very difficult. There's been very little formal education in these fields in the past. In fact, this subject is a direct response to articles like this one that suggest we need to embed a better further understanding of science, of social science, of understanding of empirical methods in all lawyers, because it's too late when someone's a practicing lawyer or a judge to expect them to be able to understand statistics or quantitative methods or qualitative methods, and many of those other things we're going to talk about next week. But I've included the reading here because I think it leads into that, and it also talks about that lack of a theoretical foundation, where you need to not only understand what precedents are or what these facts are, but you need to try and need theories to understand how you make sense of that. And as a foundation one, there'll be a video I'll do later on rule of law. And rule of law is one that pretty much every lawyer agrees in as a foundation theory, but we don't think about it very much until it goes awfully wrong. Until we have a situation where we have a senior minister in Parliament saying that lawyers who represent certain types of people are scumbags and un-Australian. And then suddenly we realise that the precarious idea of rule of law is under threat. And not everyone agrees that we should be a society ruled by law. Many people would prefer society to be ruled by the whims and caprices of the powerful. And those are the very people that I would suggest we need to be most concerned about. Not the least of which because it might mean our jobs. More for what it means for our actual society itself. Okay, so that's the readings for this week. The Navigating the Law section this week gives you a bit of a rundown on the databases that you can use to look at different theoretical approaches from different disciplines, so give you more to run on than just using good old Google, because many of the articles you will need to use throughout your studies that come from whatever source are locked away behind paywalls, and you can find summaries of them on Google. But of course, to get the actual text of the articles, you need to have a subscription to those journals. And our library maintains a subscription to a lot of those journals, so you may find that we have access to it. But you need to understand how to access them and get into those systems. And that's where understanding the how the databases work are important. And finally, in the workshop this week, we are looking at a literature review, which is something that those of you who've studied in other disciplines, I'm sure, will be familiar with, but it's not something we talk about much in law. And that's a process where you sit down and you just attempt to summarize what it is in all the things that you've read. And unfortunately, we tend to be very bad at this unless we do it in a more formal way. And this week, we provide some tips on trying to formalize that process and trying to get a clearer idea of what's a methodical, logical way of collecting that information, so that you only have to read articles once. You don't end up referring back and cutting back and forth all the way through. You collect all your information in one place. And a literature review in some disciplines can be a very formal thing. In fact, in psychology, I know you can publish papers that are just literature reviews, where simply what you're doing is looking at a field of study and summarising what everyone has to say about that topic. It's not really done in law, but it's done in other disciplines. In law, we find that it's done as a prelude to a major research project. If you're going to do an honours project, or if you're going to do masters, PhD, you'll need to start with a literature review. What we're going to do in this module is nothing that ambitious, but we're going to start organising our thoughts and ideas in a way where we get an idea of what a literature review is and how it's useful, and how that's something that builds skills and organisation in research that will help you whatever the context is.